All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Morning, Council. Let me call the case. This is case CV 2014, that's the wrong case number, CV15-0666, Fifth Avenue Professional Office, LLC versus Kahlon et al. This is the time set for oral argument. Council, a couple of things that I want to address before you commence your arguments. You both have 20 minutes to present your argument. Let me make sure I have the names correct here. Mr. Ayers? All right, Mr. Ayers, if you want to set aside some time for rebuttal, just let us know when you get up to the podium. And you can keep track of your time right there at the podium. There's a clock for you. We've read everything in the case. We reviewed the briefs and the record, so keep that in mind as you make your arguments. The other thing I wanted to mention to you is all these proceedings are being recorded. They'll be uploaded to our website, so I want you to be aware of that fact, that there'll be an audio and video recording of these arguments on our court website. With that said, Mr. Ayers, your argument.
Thank you, Your Honor. Good morning. May it please the Court. This case, Your Honors, presents sort of a paradigm of the 21st century real estate transaction, sort of inevitably from the change in our Constitution that allowed brokers to start, in effect, practicing law in the area of real estate. And by that I mean simply this is a transaction in which there was virtually no communication of any kind between the parties directly. There is no indication the parties ever met one another. The entire transaction was handled strictly by their real estate brokers. Now, I mention that primarily because I think it goes directly to the question of agency in this case. Because if, in fact, real estate brokers, in effect, can perform the legal functions in a real estate transaction, then they should be treated the same way as attorneys would be in such a transaction. And we'd submit to the court simply that if an attorney in this case had represented the guarantors under this lease, the court wouldn't have a moment's hesitation in concluding that the statements by the lawyer were binding on his client by reason of agency, and there should be no distinction made in this case with respect to a realtor for the reasons stated. The complaint in this case...
Is that a fact question?
I beg your pardon?
Is that a fact question?
I don't think that's a fact question, no. I think that's a legal conclusion.
So you don't think there are any disputed or potentially disputed facts concerning agency?
Oh, no, Your Honor. Obviously, I think that there's a great many fact issues concerning the agency issue in this case.
Okay.
What I meant was I don't think there's any question that
they come out
realtors
your
should
way.
be treated the same way, if you will, in this context.
Okay.
The complaint in this case states a separate claim against each individual guarantor, each of which, under the terms of the documents, is clearly individually and severally liable for the obligations of the corporate entity, which is now in bankruptcy. Also important, I think, to the court's consideration is that the guarantee specifically provides that any right to require the lessor, my client, to proceed against any other guarantor is specifically waived. So the guarantors in this case had absolutely no reason or basis to assume that all of them were ever going to be sued, because Fifth Avenue, the appellant in this case, could have sued virtually any one of them for the entire amount due without naming any of the other parties. I know the court probably is scratching its head as to why Dr. Putlitz was named as a defendant in this case, and I will tell you that was simply a clerical error. There is a spelling issue in this case with the names of the various defendants, and our paralegal was instructed to look at the lease addendum, which is in the record. The lease addendum basically lists all of the names, and she was told to pull the spellings from there, and she copied out all the names. We didn't realize that Dr. Putlitz had been incorrectly named until after the complaint was filed, and of course we never served him for that reason. We never really had a chance, obviously, as the record reflects, to do much else with the complaint due to the motion to dismiss. There are various arguments made by the appellees and trying to address them all individually and organize it in a sensible way is pretty difficult, but I'd like to address at least one of those right now, and that's this right of contribution argument, because I think it bears what I just quoted, if you will, from the guarantee bears on that question, that namely the various guarantors didn't have any expectation or basis for any expectation that they could rely upon the appellant suing any other guarantor for the amount of money that's due, because that's clearly addressed in the guarantee. And also, going to Your Honor's question regarding agency, that the premise, the right of contribution argument is premised obviously on the argument that the guarantors didn't know that one of their number had not signed the guarantee when it was delivered.
Say that again?
Pardon me?
What was that last statement? What was your last statement? What did you just say?
I said I think the right of contribution argument, Your Honor, is premised on the assumption that the other guarantors did not know when the guarantee was delivered that the one signature was missing. And the evidence that was put in front of the trial court very clearly shows that not only their office manager, who, with regard to the question on agency, one might consider their agent, knew before it was delivered that Dr. Putless hadn't signed it, and certainly their broker knew that because he indicated as much in an email to our broker indicating that the missing signature shouldn't be a problem. It really strains the credulity of the court to believe that both the office manager for these guarantors and their real estate broker knew of this fact, and none of them did. Plus, it leaves hanging the very, I think, pertinent question of who was it that told the office manager to instruct the broker to tell my client that they needn't worry about this missing signature because they could rely upon all of the other guarantors' signatures on the document.
Speaking of missing signatures,
I'm sorry, Your Honor?
I said, speaking of missing signatures, the copy of the addendum that I have listing all of these additional guarantors is initialed only by somebody who looks like an @ sign, but I don't know who initialed it and whose initials are missing on that addendum.
Okay, Your Honor, I'll have to find that. I
At
believe
page 56 of your brief. I believe that's correct.
Your Honor, I believe all the transactional documents, the lease and the addendum, were signed by the then president of ANI, who I believe was Mr. Kahlon.
Well, yeah, we have somebody whose initial looks like an @ sign, and we have somebody whose initials are MK, and strangely, that one addendum listing all the guarantors is only initialed by the person who initialed on the left with the @ sign, but not by MK. I'm wondering who is missing.
Your Honor, I am not finding what you're asking about. I apologize, but you said...
Well, do you have a copy of the addendum?
I do here.
Okay. Do you see at the bottom where it says initials?
Oh, I see. Okay. No, I got it. Well, Your Honor, I have no explanation for that. The previous page...
Well, can you tell me who is missing? Which
Who is
side's
missing?
initials are missing?
Yes, Your Honor, certainly the lessor is missing. MK is Melinda Kahlon, who was the president of ANI.
Okay.
Okay, so they're the corporate entities' initials are in fact on there through their president.
So the party who is effectively being stuck with the effects of this amendment or this addendum under Naismith never initialed it.
No, just the opposite, Your Honor.
The landlord is not.
The landlord is the entity that did not.
That's what I'm saying.
Initials are missing.
Right.
Yeah.
And if this addendum were ineffective, then presumably the guarantors listed on the first page of the lease document would be the only guarantors.
Would be
The only guarantors.
on the first page of the lease addendum.
Uh-huh.
I think.
No, not the addendum. The lease itself.
Well, the lease itself, Your Honor, I think provides that all of the principles of A&I are going to, in fact, guarantee the lease. Again, I'd have to go back, and there's a great deal of paper in this very small print, but
It's just that when we start talking about arguments concerning the statute of frauds, and we want to get real picky about when something's missing from a blank on a form, we have to look at all the blanks on the form, and I'm a little confused as to what's missing where, but I think you've clarified one of those issues, so thank you.
okay, Your Honor, I also, an exception to the statute of frauds would be through performance and acceptance of the benefits of the lease, which is one of the things that we've clearly argued in our brief. Go back to my notes here. We'd submit to the court that the broker in this case clearly had actual authority from both A&I and the guarantors to negotiate not only the lease but also the guarantee. This is, the facts indicate that the efforts by the broker to obtain the missing signature spanned actually several weeks. There's more than one email, one in August and one later in September that addressed the subject. Mr. Gabuzzi, the broker for the guarantors and A&I, listed the guarantors, or they did themselves. There be no other sources, we said in our brief, for the landlord to have had those names. He took care of the paper. Well, he negotiated the guarantee to begin with, and then he took care of all of the legwork necessary to get all the various signatures on the guarantee. That again spanned nearly a month. He communicated repeatedly with the broker for the landlord regarding both the guarantee and the lease, and ultimately, as the record indicates, he indicated to the landlord that the missing signature and Dr. Putlitz declining to sign this document was not going to affect its validity as to the rest of the guarantors. And ultimately, of course, he also delivered the guarantee. So if you look at the facts underlying this transaction, it's very difficult, and we would contend impossible for the court really to conclude that, as apparently the guarantors are arguing, Mr. Gabuzzi, their broker, had essentially gone rogue and was doing all this on his own without their authority. Secondly, if he didn't have actual authority to do that, then he certainly had apparent authority to do that. We've cited the case law on that extensively in our brief, and I won't go into all the details of that because I do want to reserve a little bit of time for reply. Mr. Gabuzzi, their broker, one would contend, certainly had a reasonable belief that he was authorized to make this representation to the landlord, having been instructed specifically to do so by the defendant's office manager. So again, in order to buy into the concept that the guarantors were somehow completely free and clear of Mr. Gabuzzi, the court would have to conclude that they're also free and clear of their own office manager. So I go back to something I said earlier in the argument. Who was it that instructed the office manager to tell the broker to make this representation? Whoever it was had to know going in that Dr. Putlitz had not signed the guarantee and had to specifically tell their office manager to take care of it in the manner in which it was taken care of. And going back to Your Honor's question, is important to this appeal, the ultimate question of whether Mr. Gabuzzi, the broker, was in fact an agent of the guarantors is clearly a question of fact. The case law makes that absolutely clear, and we've cited all that law in our brief. The other issue there with the guarantors is that accepting the benefits of an unauthorized act, assuming it was unauthorized, one purporting to act as their agent amounts to ratification of the representation of the agent. And again, this is not a situation in which the guarantors failed to, in fact, accept all of the benefits of the lease, including the tenant improvements my client paid for, and the free rent they were given, and my client's payment of the real estate commissions. They, in fact, occupied the lease and practiced medicine out of there for about 13 months before they finally breached the lease and moved out. On the procedural issue, I think that's adequately covered in our brief. I do want to talk about the case law a little bit on Nesbitt, so I'm just going to refer the court back to the briefs, but I think that it's quite clear that this motion should have been converted and treated as a motion for summary judgment under the rule. The case law here, Your Honors, is pretty slim. There isn't a lot of case law dealing with this issue, even around the country. If you do a full search on it, you find that you can actually read most of the cases in an afternoon. The Nesbitt case, which is the only authority cited by the guarantors in their motion, has been cited, as we said, twice by the Arizona appellate courts, in both of which the appellate courts declined to follow this so-called, quote, general rule, unquote, finding essentially on the facts of those cases that the cases were distinguishable and ultimately concluding that they should be decided on the merits rather than based upon this, we submit, outdated rule. And as we pointed out in our brief, if you look at the case law and the way it's developed over the last 50 years, what you find is that the courts have essentially created a three-pronged, if you will, test on this. First of all, if you want to sign a document, an agreement, and you don't want to be bound by it, you need to essentially declare that at the outset. You need to make it clear to the parties on the other side that you don't intend to be bound unless everyone, in fact, executes the agreement. That's simply a drafting issue. That's easy to handle.
Didn't that happen in this case?
No.
No?
No. No, there was essentially no indication by anyone with regard to the significance, if you will, of the missing signature other than the emails saying essentially, don't worry about it, you have everyone else, so it shouldn't make any difference. Secondly, that if in fact you sign the contract, you're bound by it and you can't escape liability simply by claiming in a self-serving manner that you didn't intend to be bound by it unless everyone signed. And third, as significant also to the issue of the motion for summary judgment conversion, the burden of proof on that rests on the party trying to avoid the contract, in this case the guarantors. That's the law that's been adopted in California, District of Columbia, Florida, Illinois, Indiana, Mississippi, Michigan, and Utah. All those appellate courts have looked at this issue, and all of them have come down on this three-prong approach, if you will. And we just submit that the court should adopt that approach. It's good law, and it should be the law in this state. There's a whole list of factual issues involved in this case. Their intent in delivering the guarantee without the missing signature when they knew or didn't know that it was missing, whether their real estate agent bound them as their agent, who authorized him to make the representations that were made, and it goes on and on. I do have about a minute and a half left, which I'm going to save for my reply.
All right, thank you, counsel. Mr. Messing, your argument?
May it please the court, Jeffrey Messing appearing on behalf of the Sayel defendants. Mr. Ditch is also present on behalf of the Reddy defendants, and Ms. Dominguez on behalf of the Kahlon defendants. Mr. Ayers' argument shares much in common with his briefs and his pleadings below, which is that a lot of what he's saying is not anywhere in the record. There is nothing in the record that says the entire transaction was between the brokers. There is nothing in the record that says that naming Mr. Putlitz, Dr. Putlitz as a defendant in the suit was a clerical error.
But there is more in the record than the court was entitled to consider on a motion to dismiss. Would you agree with that?
Yes, Your Honor.
So the court violated the rule.
I don't think they did. I think that the reading of, at least my reading of the court's minute entry, is that the court recited the procedural history. It summarized the arguments, but when it ruled, in its ruling, it was ruling based on the complaint and the controlling case law. And my understanding...
But it doesn't have the discretion to simply ignore materials submitted in response to a motion to dismiss. It has the obligation to convert the motion.
I believe, Your Honor, that the case law indicates that the court is obligated to convert the motion if it considers the evidence in its ruling. An actual order striking the extraneous material is not a requirement.
Oh, no, I'm not suggesting, and believe me, I would never suggest that an order striking anything is appropriate. But what concerns me is an interpretation of the rule that would suggest that a party opposing a motion to dismiss can introduce factual material, and the court can avoid conversion just by saying, I'm going to ignore this and rule on the complaint. I don't think that's what the rule is intended to require.
Your Honor, I believe, though, that that's what this court ruled in Balin Loan Investors and the strategic case. And frankly, there was a recent unpublished decision that I believe you were on the bench for, Madison. I'm mispronouncing it, Madison versus City of Scottsdale. And I think what those cases all say is that there's no conversion where the extraneous material was not necessary to the outcome.
I think another way of saying that, if you'll give me a little bit of license as an author, is that the conversion is not required when the extraneous material could not affect the outcome.
If you interpret it that way, then I would agree with you that in this case it should be converted, although you come back to the fact that the extraneous material in this case was inadmissible. We're talking double hearsay, and the affidavit itself confirms exactly what we're actually arguing, which is that plaintiff keeps saying that the broker and the office manager was defendant's broker and defendant's office manager. The defendants in this case are 18 individuals.
At this, given the paucity of the record, at this stage I would agree that that probably isn't controlling on the outcome of today's argument. But it seems to me that we need to consider the legal question whether Naisbitt compels the result that the trial court reached as a matter of law, rendering the factual material submitted immaterial. And in that case, that's when conversion isn't required, is when the factual material is immaterial, right? So if we focus on that, we have to ask, who are the guarantors, right?
Correct.
And your contention is the guarantors are everybody listed on page 1 of the lease in paragraph 1.11, and everyone listed in the addendum, and it can't be one person less, because to do so would be a modification in violation of the statute of frauds. Am I tracking you?
Yes, Your Honor. Plus, it would also violate the expectation of the parties, because if you look at the lease and the actual holding of Naisbitt in that line of cases, it's an incomplete contract if you're missing the signature.
Well, and the expectation of the parties, I think, is something that reasonable people can and have debated. Let me ask you, without asking what's reasonable and what's unreasonable, how does a court resolve what's reasonable and unreasonable? By what method?
If the issue is what's reasonable, then unless the court can rule as a matter of law, then that would normally be a fact question, and I would concede that. However, in this case, what we keep having to come back to is what's actually the allegations of the complaint, and if you convert it to a motion for summary judgment, well, what's the admissible evidence that was submitted to create a genuine issue of material fact? And in this case, there was no admissible evidence submitted.
Well, let's pause on that for a moment and let's stick with the law if we could. Okay?
Sure.
There was performance of this agreement for a time, yes?
By whom, Your Honor?
Say by both sides. One side delivered possession, the other side paid rent. That sounds like performance of a lease to me.
Again, Your Honor, which contract? A&I, the corporate entity who is the tenant, who is not a party to this litigation, paid the rent. The only evidence that the 18 individual defendants took possession, which is what plaintiff keeps referring to, is the unsworn assertions of counsel.
I don't think the analysis really hinges on who took possession. The fact is that Fifth Avenue delivered possession when the lease agreement itself provided that the guarantee was an essential component without which the lease would not take effect.
True, Your Honor, but there is nothing in this record to indicate that the guarantors, as opposed to A&I, the corporate tenant, was aware that essentially the landlord was waiving that condition.
So are you suggesting that the guarantors then had a reasonable expectation when one of, and I'm using the term guarantors colloquially right now because we're going to get to what that term really means in the context of this case. But if we include everybody who's a potential guarantor, that all guarantors can breathe easy and say, my signature on that document meant nothing because one guy didn't sign.
I think what you should be saying is that if you're going to change the contract so that I'm going to have a guarantee without everybody's signature, you at least need to tell me that and get my consent. And there is nothing in this record that indicates that happened. You can't change my contract after I've signed it and not tell me and get me to agree.
And this gets to your...
Nothing by the guarantors.
Right.
So basically then, it kind of puts the guarantors in a neat position because you can sign a lease, you can identify the guarantors on the front page of the lease, do an addendum with a whole list of people, and then if one of them just doesn't sign, then we're in Fat City because we don't have a guarantee that's enforceable against us, but we have possession. That seems to encourage a certain amount of commercial gamesmanship.
No, Your Honor. What it encourages is for the landlord to act in a commercially reasonable fashion. The landlord has complete control here. The landlord can say, I'm not going to give you possession until you give me all the signatures, or the landlord can get everybody to sign off saying, okay, we're all agreeing to waive the missing signatures, or we can say, tell you what, I will conditionally let you have possession if you agree that if you don't give me the signatures by X date, you're out.
That would be good practice.
All of that is, but what you can't do is have me sign a contract and then change a material term after I've signed it without telling me and getting my consent. And there is nothing in this record that indicates that anyone told the 17 people who signed that they were on the hook without the 18th signature.
Well, the addendum is now being used to deprive the landlord of its rights under the plain terms of the lease. And I hate to be picky, but the landlord didn't initial the addendum.
First, Your Honor, it's not in the record, Mr. Ayers' interpretation.
No, but the lease is in the record, and I can see the blank very
But,
clearly.
Your Honor, if you take a look at the prior page, which is the signature page, I think you will agree with me. Actually, is it the prior page? 2 pages prior. Maninder Kahlon, MK, the initials that do not appear on the addendum,
Right.
is one of the defendants. Mr. Ayers misspoke.
Okay. Well,
MK is the tenant, not the landlord.
and I do agree with you. That's an important clarification. But does it change the effectiveness of the addendum? I mean, if you're saying that the tenants have the right to be up in arms about having their contract amended without their consent, and they didn't even consent to this addendum that made them all guarantors, how do we pursue a statute of frauds analysis on that?
Well, Your Honor, if you take a look at I don't know where, it's the last page of the attachment to the complaint. It's the page where all of the guarantors except Dr. Putlitz actually signed. I think you have to read the document as a whole, and yeah, they didn't initial the addendum, but they were given the signature page with everybody's signature on it, and everybody except for Dr. Putlitz signed.
So we have an addendum that modifies the lease that was actually signed, that's not signed by the tenants, and we're going to say that's effective.
No,
but we're
what
not going to say that an amendment, a de facto amendment by performance is effective, because that would violate the statute of frauds.
I think, Your Honor, that if you could show me de facto performance by the guarantors in the record, I would agree with you that that can modify the contract or waive the condition. What our argument is that there is nothing in the record that says that the guarantors performed. I mean,
To think of what might have been if the court had followed the rule on conversion, though. I mean, the record is very, very slim. I'll grant you that, and I understand your legal theory, and I'm not saying that your reasoning is necessarily flawed in the abstract. But we have a rule that requires conversion, and we have a conversion that didn't happen, which is really responsible for the slim record.
not really, Your Honor, because let us assume that the judge converted, okay? Mm-hmm. I think the case law is very clear that what a reasonable opportunity under Rule 56E, I think it is, requires under that circumstance is an opportunity to submit the written response. It was the plaintiff who submitted the extraneous materials. And I believe the case law is clear, is that's the reasonable opportunity. It was the defendants who didn't incorporate any additional materials. And keep in mind, Your Honor, this is not a case where the plaintiff either moved to amend or asked for a 56F continuance. They made the tactical decision to stand on the complaint and their hearsay extraneous materials. That's their choice. And if you're going to view this as a 56 summary judgment case, they had their day in court, they submitted their materials, they didn't have any admissible evidence. So viewing this as a straight summary judgment issue, well, it is defendant's burden, the non-moving party's burden to submit admissible evidence sufficient to raise a genuine issue of material fact.
Understood.
Everything they submitted was hearsay. And
Of course, there's one level of hearsay in every summary judgment response. Right?
I understand that, Your Honor, but they submitted their office manager's affidavit to say that the office manager and broker of A&I, even their office manager doesn't say they were the office manager and the broker of the 18 individual guarantors.
Right.
Said this. Now, they, without any evidence of agency at all for the guarantors, want you to make the leap to say that office manager and that broker was authorized to speak on behalf of all 18 defendants, who, by the way, include the spouses. And there is nothing in the record to even indicate that any of those folks had ever authorized them. I mean, again, plaintiff is speculating as to, well, who authorized the office manager? Judge, the honest answer to that question is, we don't know.
I think I hear what you're saying, but I think part of the problem here is how broadly you read Naisbitt when you have a factual situation where there has been performance of the underlying agreement. I understand you want to separate the guarantee and the agreement, but it's very difficult to perform a guarantee until you're called upon to do so. There has been reliance by the landlord on the existence of a nearly completely signed guarantee, or depending on which portion of the lease you read, a completely signed guarantee, in delivering possession. And I'm curious whether you have any authority other than Naisbitt to suggest that that one missing signature is dispositive.
Well, I think, Your Honor, you come back to the basic issue of, and I can't cite you a case off the top of my head, back to the proposition that you don't get to change my contract without telling, after I've signed it, without telling me and getting my consent. I mean, that's really what it comes down to. I agree that when I signed the guarantee, I intended to be bound. But you don't get to change the terms of my guarantee without getting me to agree to it.
Okay. Understood. Thank you.
If I could have a second to flip through my notes, I think I sort of covered a lot of it. Your Honor, when we talk about the possession, again, there is nothing in this record that indicates that any of these defendants took possession. And I certainly took possession, or at least you can say it's alleged in the complaint, and it's sort of implicit in what happened.
Well, as I said to your colleague, I think possession was delivered.
Absolutely. Okay. But to A and I, there is nothing to indicate that possession was, I mean, remember, it is a separate contract, Your Honor. I mean, I can guarantee your lease for you without ever setting foot in that space. It's not a requirement that I get the benefit of your lease if I'm willing to sign the guarantee. And so my point is simply, Your Honor, if you're going to talk about the benefit that the guarantors got, well, you gotta talk about whether they knew it. Now, if the benefit is that A and I took possession, I think you can infer that from the complaint if we're viewing this as a motion to dismiss. But if we're viewing this as a motion for summary judgment, where's the admissible evidence?
That there was possession?
Yeah, there's evidence that there was payment and a breach. But you know, if we're going to be picky about this, Your Honor,
well,
I mean, do I believe there was possession? Yeah. But is it in the record? No.
No, but we're talking about now.
It's a reasonable inference from the fact that rent was paid.
And we're also talking about a defendant's motion, which is very different from a plaintiff's motion. A plaintiff's motion has to establish every element. A defendant's motion does not. It just has to identify one genuine dispute of material fact to the relevant evidentiary standard. Defendants have an easier time on summary judgment.
Okay. Just briefly, if we're going to talk about, as plaintiff continually does, try to interchange the 18 defendants with the corporate tenant, we are talking about piercing the corporate veil. And, you know, that's, well, I mean,
I'm not disagreeing with you.
And you know, the only, quote, basis that we're given is counsel's statement that it would be fraud. Well, that's not a basis to, I mean, an unsworn statement is not a basis to pierce the corporate veil. I mean, if you want to submit evidence that would raise a factual question about lack of capacity, lack of corporate formalities, you know, we can run down the list of the bases on which you can pierce the corporate veil. We can talk about that. But that's not in the record. You don't get to just say, gee, I'm going to talk about A&I's broker and A&I's office manager and make believe that I have something that says they represent and have the authority on behalf of the 18 individual defendants. If you're going to do that, the law on agency is real clear. The apparent authority has to come based on the acts of the principal. And there is nothing showing that the 18 individual defendants in this case ever authorized the broker or the office manager to act on their behalf. And in fact, the only evidence there is the lease that specifically says that the broker is the exclusive broker of A&I, not the individual defendants.
Okay, thanks.
Thank you, counsel. Mr. Ayers, your rebuttal?
Thank you, Your Honor. I have a minute and a half, so I'll be very brief. First, with regard to the issue of not having amended the complaint characterized as a strategic decision, the court should note in the record that the only basis in the original motion to dismiss for dismissal of the case was the reliance on the Nesbitt case. All the rest of this information was generated essentially in the reply. Amending the complaint would have done absolutely nothing, because we could not change the fact, obviously, that one of the guarantors had not signed the guarantee, which was the sole basis for the motion to dismiss. So there was very little, if any, point in trying to amend the complaint. Secondly, I heard probably 15 times that there was missing evidence. There is missing evidence in this case. We agree with that. That's why we've asked that the case be reversed and remanded so that we can present the evidence. There was really no opportunity afforded to the plaintiff appellant in this case to present evidence other than the response to the motion to dismiss. We pointed out in our brief that with respect to this hearsay argument on the representations of the broker, that first of all, there's been no real explanation as how those are hearsay. But secondly, even if the court were to consider them hearsay, they are no longer hearsay if, in fact, the court concludes, as we think it must, that Mr. Gabuzzi, their broker, was acting as their agent. If he was not, then they were acting on their own behalf. I hope the court is scratching its head and saying, how in the world are these guarantors who were directly in the center of this transaction, who signed a document acknowledging that the landlord would never have agreed to the lease in the first place without their guarantees, are somehow entirely strangers to this transaction and have no involvement in it? Because that's essentially the premise that you're being asked to accept. So we would ask the court to reverse this case, remand it for trial. Thank you.
Thank you, counsel. We'll issue a written decision in due course. This matter is under advisement. Court's in recess.